The 14-year-old black boy stood at the defense table beside his mother, Elena Jordan, facing eviction after 8 years in her apartment. His name was Mason Jordan. He wore a borrowed suit 2 sizes too large and carried a briefcase held together with duct tape. Elena wore hospital scrubs, exhausted from her overnight shift. Judge Patricia Hendricks looked up when Mason spoke. "Your Honor, I'm my mom's lawyer." Hendricks laughed, not politely, a sharp, mocking laugh that filled the courtroom. "Son, I don't know what YouTube video you watched, but this is a real eviction hearing. Adults lose their homes here. Now sit down before you embarrass your mother more than you already have." Across the aisle, Richard Brennan didn't bother hiding his grin. "Jesus Christ," he muttered to his paralegal loud enough for the whole room to hear. "A kid with a duct tape briefcase. This is the best defense they could scrape together?" Then Mason spoke again, and the first 3 words made Brennan's smile disappear. "Let me take you back to how we arrived at this moment, because this story isn't just about one hearing. It's about what happens when the system assumes you can't fight back." Elena Jordan sat beside her son in the second row of family court. Her hospital scrubs still carried the antiseptic smell of her overnight shift. She'd come straight from work because she couldn't afford to miss this hearing, couldn't afford to lose her apartment, couldn't afford much of anything anymore. Her fingers trembled as she signed the court registry. 14 years of raising Mason alone, 8 years in their rent-controlled apartment. All of it now hung on what would happen in the next hour. The apartment wasn't much. 2 bedrooms in a building that had seen better decades. But it was theirs. Mason had learned to ride his bike on that sidewalk. Elena had planted herbs in the window boxes every spring. The neighbors knew each other's names. In a city where rent devoured paychecks, their below-market lease was the difference between stability and crisis. Now, Pinnacle Property Management wanted them out. The eviction notice had arrived 6 weeks after Elena filed her complaint with the building inspector. The timing wasn't coincidence. Mason sat straighter than usual. His borrowed suit hung loose on his thin frame. The tie was slightly crooked despite Elena's attempts to fix it that morning. He'd insisted on wearing it, insisted on coming prepared. For 6 months, he'd spent every afternoon at the Central Library. Reference section, 3rd floor. The law librarian had stopped asking questions after the first week. She just pointed him toward the legal databases and let him work. He'd filled 3 notebooks with case citations, learned the difference between precedent and dicta, studied rules of evidence and civil procedure, watched hours of courtroom footage online. His friends thought he was obsessed. His teachers thought he was wasting time. Elena thought he was trying to help in the only way he knew how. None of them understood what he was actually planning. Across the aisle, Richard Brennan unpacked his leather briefcase with practiced efficiency. 20 years representing landlords had taught him exactly how these hearings went. Tenant shows up, maybe with a friend for moral support. They tell a sob story. He presents documentation. Judge rules for the property owner. Entire process takes 15 minutes. He'd already scheduled his lunch meeting for 11:30. This wouldn't take long. Brennan had the kind of reputation that preceded him. 300 eviction cases, 297 victories. The losses were technicalities. Paperwork errors his assistants made. He didn't lose on merit, ever. Pinnacle Property Management paid him well to ensure tenants understood the futility of resistance. This case was particularly straightforward. Single mother, no legal representation, documented lease violations. He'd written the brief in 20 minutes. Judge Patricia Hendricks entered and everyone rose. She'd been on the family court bench for 12 years, efficient, fair, impatient with theatrics. She ran her courtroom like a well-oiled machine. Morning docket started at 9 sharp, lunch break at noon, no exceptions. She valued preparation, respected the law, and had 0 tolerance for people wasting her time. This eviction hearing was case number 7 on a docket of 19. She expected to be done by 9:45. The bailiff called the case. Pinnacle Property Management versus Elena Jordan. Hendricks reviewed the file quickly. Standard eviction petition, tenant in rent-controlled unit, multiple documented violations, property company seeking immediate possession. Nothing unusual, nothing that required more than basic attention. She looked up, ready to begin. That's when Mason stood and walked to the defense table. Hendricks watched him arrange his papers with the careful precision of someone trying to look confident. The oversized suit, the duct-taped briefcase, the nervous energy barely contained beneath a mask of determination. She'd seen family members provide moral support before. Sometimes they even spoke up during testimony. But this felt different. The boy carried himself like he belonged there, like he had a plan. Mason placed his hands flat on the table. He took one deep breath. Then he looked up at the judge and spoke in a clear voice that carried across the courtroom. "Your Honor, I'm Mason Jordan. I'll be representing my mother today." The words hung in the air. Brennan's pen stopped mid-note. The court reporter glanced up. Elena closed her eyes. Hendricks removed her glasses and rubbed the bridge of her nose. "Son," she said slowly, "this isn't career day." Her tone wasn't unkind, just tired. Just another complication in an already long docket. "Where's your mother's actual attorney?" She looked past Mason to Elena. "Miss Jordan, do you have legal representation?" Elena started to stand, but Mason spoke first. "I am her attorney, Your Honor." His voice didn't waver. "And I'm ready to proceed." Hendricks stared at him. Brennan actually laughed out loud, a short bark of genuine amusement. He turned to his paralegal and whispered something. They both smiled. This was going to be even easier than expected. But Hendricks was already thinking through the procedural implications. The boy was serious. Misguided, certainly. Unprepared, probably, but serious. She leaned forward. "Young man, do you understand what legal representation means?" Mason nodded. "It means I advocate for my client's interests according to law and procedure." Hendricks raised an eyebrow. "How old are you?" 14, Your Honor. "Have you passed the bar exam?" "No, Your Honor." "Do you have a law degree?" "No, Your Honor." Brennan stood, unable to resist. "Your Honor, this is inappropriate. The petitioner objects to this child playing lawyer. We request the court proceed with eviction on default since respondent has no qualified representation." He was already imagining the story he'd tell at lunch. A kid with a briefcase, property law as pretend courtroom, the absurdity of desperate people. Mason didn't look at Brennan. He kept his eyes on the judge. "Your Honor, under Federal Statute 28 U.S.C. Section 1654, any party may proceed pro se in any court of the United States." His pronunciation was careful, practiced. State Family Court Rules Section 3.02 allows for pro se representation in eviction proceedings. My mother has designated me as her representative. I'm prepared to proceed. The courtroom went quiet. Hendricks put her glasses back on. That was actual law, correctly cited. Not just memorized words, but the right statute for the right situation. She looked at the boy differently now, still skeptical, still concerned, but curious. "Mr. Jordan," she said, testing how it sounded, "do you understand that pro se representation carries significant risks, that you'll be held to the same standards as a licensed attorney?" "Yes, Your Honor." Mason's hands were steady now. "I understand the responsibility. I'm prepared to meet those standards." Hendricks glanced at Elena. The mother looked terrified and proud in equal measure. The judge made her decision. "Against my better judgment, I'm going to allow you to proceed. But understand this, you get no special treatment, no extra time, no second chances. You follow procedure, or I'll hold you in contempt. Clear?" Mason nodded. "Yes, Your Honor. Thank you." Brennan's smile had faded. This was unusual. Not necessarily problematic, just unexpected. The kid knew one statute. That didn't mean he knew law. Didn't mean he could actually mount a defense. If anything, this made things easier. No competent attorney would let their client be represented by a child. This was proof of poor judgment. He'd use it in his argument. He settled back into his chair, already revising his approach. Hendricks looked at her clock. 9:23. This was going to throw off her entire morning. "Mr. Brennan, you may present your opening statement." Brennan stood and buttoned his jacket. Time to get this back on track. Time to show everyone why this was a waste of the court's time. Time to make a child understand that some battles can't be won by enthusiasm alone. He walked to the center of the courtroom with the confidence of 300 victories. "Your Honor, this is a straightforward case. The petitioner seeks eviction based on documented, repeated violations of the lease agreement. We have photographic evidence, testimony from property management, signed documentation of multiple warnings." He gestured to his stack of exhibits. "Miss Jordan has shown a pattern of disregard for the terms she agreed to. The law is clear. Lease violations constitute grounds for eviction. We request immediate judgment for the petitioner. Brennan laid out each violation with practiced precision. Unauthorized pet in unit. Excessive noise complaints from neighbors. Unauthorized additional occupant. Late rent payments. Each violation supported by documentation. Each violation grounds for lease termination. He made it sound inevitable, made resistance seem pointless. This was what he did. He built walls of paper that crushed hope. He concluded with a personal touch. Your Honor, we understand Miss Jordan's situation is difficult, but property owners have rights. Other tenants have rights. The lease exists to protect everyone. When one person refuses to follow the rules, everyone suffers. The petitioner simply asks that the court enforce the agreement Miss Jordan voluntarily signed. He returned to his seat. Clean argument, solid documentation, 14 minutes, right on schedule. Hendricks made notes. Everything Brennan said was technically correct. If the evidence supported the violations, eviction was appropriate. The law didn't care about circumstances, only about whether the lease was breached. She looked at Mason. Mr. Jordan, your opening statement. Part of her hoped he'd ask for continuance, admit he was in over his head, save himself the embarrassment of trying to argue law he didn't understand. Mason stood. He didn't walk to the center of the courtroom. He stayed at the table, one hand resting on his papers. When he spoke, his voice was quieter than Brennan's, but somehow it carried more weight. Your Honor, this case isn't about lease violations. It's about retaliation. It's about a property management company that punishes tenants for demanding basic safety. He paused. 3 months ago, my mother reported dangerous building code violations to the city. Broken heating in winter, exposed electrical wiring, black mold in the bathroom. Mason's voice remained steady. The building inspector confirmed every violation she reported, gave Pinnacle Property Management 30 days to fix them. They didn't fix anything. Instead, 6 weeks later, we received an eviction notice. Not because my mother did anything wrong, because she did something right. She spoke up. He looked directly at Hendricks. State law prohibits retaliatory eviction. When a tenant reports code violations, the landlord cannot evict in response. That's exactly what happened here. He reached for a document. This timeline shows the sequence of events. January 15th, my mother files her complaint with building inspector. February 3rd, inspector confirms violations. February 20th, we receive eviction notice. March 1st, property management files this petition. Mason held up each document as he mentioned it. The so-called violations in their petition all allegedly occurred during this same period. All documented for the first time after my mother's complaint. All conveniently providing grounds for eviction. Mason set the papers down. Your Honor, the petitioner wants you to believe my mother suddenly became a bad tenant. But she's lived in that apartment for 8 years without a single complaint. 8 years of on-time rent. 8 years of being a good neighbor. Then she reports safety violations and suddenly she's violated her lease 4 different ways. He shook his head slowly. That's not a pattern of bad behavior. That's retaliation disguised as enforcement. He gripped the edge of the table. His voice dropped lower, more intense. And I can prove they fabricated the evidence. Brennan shot to his feet. Objection, Your Honor, this is speculation. Accusation without foundation. I move to strike. But Hendricks held up her hand. She was leaning forward again. Overruled. Mr. Jordan, you'll have opportunity to present your proof. Continue. Mason nodded. The law exists to protect people like my mother. People who don't have expensive lawyers. People who live paycheck to paycheck. People who would rather stay silent than risk losing their home. His eyes met the judge's. But silence protects the wrong people. My mother refused to stay silent, so Pinnacle tried to silence her differently. They tried to make her disappear. That's what this eviction really is, an attempt to remove a witness before the code violation hearing. He returned to his seat. I'll prove the violations were fabricated. I'll prove the timing was retaliatory. I'll prove my mother's only crime was refusing to accept dangerous conditions. Mason sat down. The courtroom was absolutely still. Hendricks wrote for a long moment. Then she looked up. Mr. Brennan, call your first witness. Her tone had changed, less routine, more engaged. Mason had done something unexpected. He'd made her want to hear what came next. Brennan called Mr. Delaney to the stand. The property manager was mid-40s, thinning hair, cheap suit. He'd testified in dozens of eviction cases. Always composed, always prepared, always believable. He took his oath and settled into the witness chair. Brennan walked him through the violations methodically, each supposed incident, each piece of documentation, each warning allegedly given to Elena, standard testimony, rehearsed but not obviously so. Then Hendricks nodded to Mason. "Your witness, Mr. Jordan." Mason gathered his papers and approached. He moved slowly, deliberately, like he was thinking through each step. He stopped a few feet from the witness stand. "Mr. Delaney, you manage the property at 423 Ashford Street?" "Yes." "How many units?" 32. "How long have you been manager there?" 4 years. Mason nodded. Simple questions, building rhythm. "You testified about an unauthorized pet, a dog my mother allegedly kept in the apartment." Mason held up a photograph. "This photo is dated August 12th of last year. Is that correct?" Delaney glanced at it. "That's what the date stamp shows, yes." Mason moved closer. "But the metadata on the digital file shows it was actually taken November 9th, 4 months later. Can you explain that discrepancy?" Delaney's confident expression flickered. "I don't know anything about metadata. The date on the photo is what matters." Mason pulled out a printed report. "This is a digital forensics analysis of the file. Shows original creation date, modification date, and embedded GPS coordinates. All the photos you submitted were taken on November 9th, 3 days after my mother filed her building code complaint. Not in August, like your documentation claims." Brennan objected. "Your Honor, we weren't provided this analysis in discovery." Mason turned. "It was provided yesterday by email." "Confirmation of receipt is in the court file." Hendricks checked. "It's here, Mr. Brennan. Objection overruled." She looked at Delaney with new interest. "The witness will answer the question." Delaney shifted. "I may have gotten the dates mixed up. Lots of properties, lots of photos." Mason moved to the next violation. "You claimed excessive noise complaints from neighbors, specifically from apartment 21B. Who lives there?" Delaney checked his notes. "That unit is currently vacant. Currently vacant. When did it become vacant?" "November sometime." Mason already had the document ready. "Property records show 21B has been vacant for 11 months. Pinnacle owns it outright, uses it for storage. So who exactly complained about noise from that unit?" The property manager's neck reddened. "There were other complaints from other neighbors." Mason held up a request form. "I filed a public records request for all noise complaints filed about apartment 12C, where my mother lives. This is the complete response. 1 complaint. Filed from unit 21B, the vacant unit. There are no other complaints. None. 8 years of tenancy and not a single neighbor ever complained about my mother." Hendricks stopped taking notes. She just watched. Brennan was furiously flipping through his files. Mason continued without pause. "The third violation claims unauthorized additional occupant, someone living in the apartment who isn't on the lease." Mason looked at Delaney. "Who did you claim was living there?" Delaney consulted his documentation. "Our inspection revealed evidence of a male occupant, personal items, mail addressed to someone not on the lease." "When did you conduct this inspection?" "November 18th. "Did you provide proper notice to my mother before entering her apartment?" Delaney hesitated. "We provided notice as required by law." Mason pulled another document. "State law requires 48 hours written notice for non-emergency inspections. My mother received a note under her door at 6 p.m. on November 17th. You entered at 9 a.m. on November 18th. That's 15 hours, not 48. The inspection was illegal." Brennan objected again. "Improper notice doesn't invalidate observations made." Hendricks frowned. "It might invalidate their admissibility, Counselor. Mr. Jordan, continue." Mason nodded. "For the record, the mail items you found belong to me. I'm 14. I live with my mother. I'm on the lease as a dependent minor, so there's no unauthorized occupant, just a property manager who didn't bother to check basic facts." The cross-examination had rhythm now. Question, answer, contradiction, document. Mason dismantled each violation piece by piece. The late payment that bank records showed was actually 3 days early. The property damage that photos proved existed before Elena moved in. The lease violation that referenced a clause that didn't exist in Elena's actual lease agreement. Every claim Delaney made fell apart under examination. But Mason wasn't done. He shifted his approach, broadened the scope. Mr. Delaney, how many evictions has Pinnacle Property Management filed in the past 12 months? Brennan stood. Objection, relevance. Mason addressed the judge. Your Honor, I'm establishing a pattern of retaliatory eviction as standard business practice. Hendricks considered. I'll allow it, but make your point quickly, Mr. Jordan. Delaney answered reluctantly. I'd have to check exact numbers, maybe 15 or 20. Mason held up a folder. Property court records show 23 eviction filings from Pinnacle in the past year. I've reviewed 19 of them. Of those 19, 7 involved tenants who had recently filed code complaints or contacted the building inspector. 7 out of 19. That's more than 1/3 of your evictions. He laid out 3 files on the evidence table. Sandra Miller, apartment 8B, filed complaint about lead paint in January, evicted in March for alleged pet violation. James Chen, apartment 14A, reported broken fire exits in April, evicted in June for alleged noise complaints. Patricia Davis, apartment 27C, complained about non-functional smoke detectors in September, evicted in November for alleged unauthorized modifications. Mason looked at Hendricks. Every single one followed the same pattern: code complaint, then sudden lease violations, then eviction. The courtroom wasn't quiet anymore. There was a low murmur, people processing implications. Hendricks banged her gavel once. Order. She looked at Delaney. Is this accurate? 7 tenants who filed complaints subsequently evicted? The property manager loosened his tie. Some tenants are problems. They complain about everything. Those same people tend to violate their leases. Mason pulled out another document. Or maybe it's the opposite. Maybe tenants who speak up become problems for management. This is the building inspector's report on 423 Ashford. 12 separate code violations cited. Every single one matches what my mother reported. The violations are real. The building is unsafe. And now Pinnacle wants to evict the person who exposed that. He paced slowly in front of the witness stand. What happens after my mother is evicted, Mr. Delaney? Does Pinnacle fix the violations? Delaney shifted. The violations are being addressed on appropriate timeline. How long does appropriate take? Because the inspector's order required completion in 30 days. That was 90 days ago. Nothing's been fixed. Delaney had no good answer. There are budget considerations, contractor availability. Mason nodded slowly. Budget considerations, that's interesting. Because I pulled the rental listings for 423 Ashford. 3 apartments have been re-rented in the past 4 months. All 3 previously occupied by tenants who filed code complaints. All 3 now listed at rates 30 to 40% higher than the previous lease. He turned to face the judge. This isn't about protecting property rights. It's about removing complainants before the code violation hearing. It's about silencing witnesses. It's about profit over safety. Brennan was on his feet. Your Honor, this is inflammatory speculation. We're talking about one eviction case, not a conspiracy theory. But Mason cut in. It's not speculation when I have documentation. Emails between Mr. Delaney and Pinnacle ownership discussing problematic tenants. Rental rate analysis showing increased revenue from evicted units. And most importantly, this. He connected his laptop to the courtroom's display system. The screen flickered to life. Security footage from a corner store, black and white, timestamp visible. November 9th, 2:45 p.m. The angle showed the entrance to Elena's building across the street. Mason let it play without commentary. 2 men approached carrying bags. One was clearly Delaney. The other held a camera. They entered the building with trash bags, a pet carrier, and cardboard boxes. At 3:15 p.m., they exited, empty-handed. Mason paused the footage. This store owner remembered me visiting the building in August. We talked. He mentioned his security system. I asked if he'd saved footage from early November. He had. Mason advanced the playback. Watch the timestamp, 3:23 p.m. Mr. Delaney and his photographer walk out of the building, no longer carrying anything. 38 minutes after entering. He pulled up a photo on his laptop. One of the violation images from Brennan's evidence. The metadata displayed clearly. November 9th, 3:12 p.m. This photo, allegedly showing my mother's unauthorized pet, was taken at 3:12 p.m. During the 38 minutes Mr. Delaney was inside the building. With a pet carrier. That he brought with him. Mason looked directly at Delaney. You staged every single violation. You carried props into the building and photographed them as if they belonged to my mother." The courtroom erupted. Hendricks banged her gavel hard. "Order! I will have order!" But her eyes were locked on the screen, on the timestamp, on the undeniable sequence of events. Brennan was frantically conferring with Delaney. The property manager's face had gone from red to ashen. Mason disconnected his laptop and returned to his table. He'd said everything that needed saying. The evidence spoke for itself. Hendricks called a 5-minute recess. When they reconvened, Brennan requested permission to redirect the witness. He tried to minimize the damage, suggested alternative explanations. Maybe Delaney was simply collecting evidence of existing violations. Maybe the timestamps were wrong. Maybe the security footage showed something else entirely. But every explanation sounded hollow. The visual evidence was too clear, the pattern too obvious. Mason's final questions were surgical. "Mr. Delaney, did you receive a performance bonus from Pinnacle last quarter?" "I received standard compensation." "Please answer the question. Did you receive a bonus specifically?" Delaney reluctantly nodded. "Yes." "How much?" $5,000. "What was the stated reason for that bonus?" Another pause. "Successfully managing problem properties." Mason let that hang. Successfully managing or successfully removing problem tenants. Brennan tried one final redirect. He focused on the actual lease violations. Even if the photographic evidence was questionable, Elena had still been 3 days late with rent. That was documented. That was grounds for eviction under the strict terms of her lease agreement. It wasn't much, but it was something. Technical violation. Enough for a favorable ruling if the judge wanted an easy out. Mason addressed it in his closing argument. "Your Honor, my mother's rent payment was 3 days late once in 8 years, due to a bank processing error. She corrected it immediately. Even if we pretend that's a material breach, State Statute Section 42.03 prohibits eviction in retaliation for reporting code violations. The statute says even if a technical violation exists, if the eviction is motivated by retaliation, it's illegal." He cited 3 appellate cases, each with nearly identical facts. Tenant reports violations. Landlord finds technical breach. Courts rule that retaliatory motive makes eviction unlawful. The precedent was clear. The law was designed specifically for situations like this, to protect tenants who speak up, to prevent landlords from using technical violations as cover for retaliation. Mason concluded simply, "The law rewards courage, not silence. My mother had the courage to demand safe housing. The law protects her for that." Hendricks took less than 30 seconds to review her notes. Then she looked up. First at Delaney and Brennan, her expression was cold, disappointed. "I've presided over hundreds of eviction cases. Most are straightforward. Tenants genuinely violate leases. Property owners legitimately seek possession. But this?" She gestured to the evidence. "This is fraud. Fabricated evidence, staged violations, illegal inspection, and what appears to be systematic retaliation against tenants who exercise their legal rights." She turned to Mason with something approaching respect. "Mr. Jordan, when you walked into this courtroom, I thought you were a child playing lawyer. I was wrong. You've presented evidence more thoroughly than some licensed attorneys I see." Her voice hardened. "And you've exposed conduct that demands investigation." She looked back at Brennan. "Counselor, I suggest you have a serious conversation with your client about their business practices." The ruling came in measured, formal language. "The petition for eviction is denied in its entirety. Furthermore, I'm ordering Pinnacle Property Management to pay Miss Jordan's court costs. The property is ordered to complete all building code violations within 30 days. Failure to comply will result in daily fines. I'm scheduling a follow-up hearing for 60 days from today to verify compliance." Hendricks wasn't finished. "I'm also forwarding the complete case file to the State Housing Authority. The pattern Mr. Jordan identified warrants investigation. If other tenants have been subjected to similar retaliation, there will be consequences." She looked at Delaney. "Mr. Delaney, you're to remain available for questions from the Housing Authority. Leaving the state without notice would be inadvisable." The property manager could only nod. Brennan was already trying to salvage something. "Your Honor, my client may wish to distance themselves from Mr. Delaney's actions. Pinnacle Property Management itself may not have been aware." Hendricks cut him off. "Save it, Counselor. Whether ownership knew or not, they're responsible for their employees' conduct. They'll have opportunity to cooperate with the investigation. I suggest they take it." She made one final note, then looked at Mason. Mr. Jordan, you're 14 years old. You taught yourself enough law to win a case that many adults would have lost. You exposed fraud that might have continued unchecked. She paused. I hope you continue your education. The legal profession needs advocates who understand that justice means more than winning arguments. It means protecting people who can't protect themselves. Elena had been sitting frozen through the entire hearing. Now she pressed one hand to her mouth. Tears ran down her face, not from sadness, from relief so overwhelming it hurt. Mason reached over and squeezed her hand. He felt the trembling, felt the years of worry and work and barely holding on. They were still holding on. They'd get to keep holding on. Outside the courthouse, the late morning sun felt warmer than it should in November. Mason loosened his crooked tie. His hands were finally shaking. The adrenaline that had sustained him for the past 2 hours was draining away. He felt 14 again, tired and overwhelmed and slightly sick to his stomach. Elena pulled him into a hug, tight enough that he could feel her heartbeat. Or maybe that was his own heart. Hard to tell. You gave us our home back, she whispered. Mason shook his head against her shoulder. I just made them follow the law. That's all. Just made them follow what they were supposed to do anyway. But Elena pulled back and held his face in her hands. You stood up when everyone expected you to sit down. You spoke when they expected silence. That's everything, Mason. That's everything. They started walking toward the bus stop. Mason had algebra homework due tomorrow, a test in history on Friday. His friends wanted to know if he could play basketball this weekend, life returning to normal. Except nothing felt quite normal anymore. He'd walked into a courtroom as a frightened kid and walked out as something else. He wasn't sure what yet, but something had changed. At the corner, Mr. Kim from the convenience store saw them and called out, I saw the news! You won! Mason hadn't realized news crews were there, hadn't thought about anyone beyond that courtroom. Mr. Kim clapped him on the shoulder. I'm glad the footage helped. That building's been a problem for years. Maybe now they'll fix it. Mason nodded. Community, support, people looking out for each other. That's what made the difference. Elena had to go to work. Night shift at the hospital started at 7. Mason would do his homework at the library and take the bus home. Same routine they'd followed for years. Except tonight, Elena wouldn't lie awake wondering if they'd have a home next month. Tonight she could just sleep, just rest, just trust that tomorrow would come without disaster. Small victories, they added up. Mason returned to the library around 3, the law section on the 3rd floor. The librarian, Mrs. Chen, looked up and smiled. I heard. Well done. She didn't make a big deal of it, just acknowledged it and went back to her work. Mason appreciated that. He gathered the law books he'd been using for months, returned them to their shelves, ran his fingers along the spines one last time. These books had given him a weapon when he needed one most. He sat at his usual desk, pulled out his algebra textbook, looked at equations that suddenly seemed less important than they used to, or maybe more important. Maybe everything was important. Every skill learned, every piece of knowledge gained. You never knew when you'd need it. When it would become the difference between justice and being crushed by a system that assumed you couldn't fight back. Tomorrow, he'd be just another freshman at Lincoln High. But tonight, he was the kid who'd beaten a property management company using nothing but preparation and truth. Both things felt real. Both things were him. You didn't have to choose between being 14 and being capable, between being young and being powerful. The law didn't care about age. It cared about evidence and argument and whether you could prove your case. So let me tell you what this story is really about. It's not about one boy being exceptional. It's about what becomes possible when you refuse to accept that you're powerless. Mason didn't win because he was gifted. He won because he refused to believe losing was inevitable. He did the work. He learned the system. He used the tools available to everyone. Public library, free legal databases, state statutes anyone can read, court procedures anyone can follow. The system works when people make it work, when they document injustice instead of accepting it, when they research their rights instead of surrendering them, when they stand in courtrooms and demand that laws mean something. Mason's story isn't rare because people like him don't exist. It's rare because most people don't know they have the power he used. Don't know that the law was written to protect them too. Retaliatory evictions are illegal in almost every state. Landlords cannot punish you for reporting code violations, cannot force you out for demanding safe housing, cannot fabricate evidence to justify eviction. But they do it anyway, because most tenants don't have resources to fight back, don't have lawyers, don't have time, don't have knowledge. So they leave quietly, and the pattern continues, and buildings stay dangerous, and the next tenant stays silent. That's what changes when one person refuses silence. When they document everything, save every email, photograph every condition, timestamp every interaction, when they learn what the law actually says instead of what landlords claim it says, when they walk into courtrooms prepared to prove their case, not with emotion or sympathy or stories, with evidence, with procedure, with law. Your local library has the same resources Mason used: free legal databases, reference librarians who can point you to relevant statutes, precedent cases you can read and cite. It's not easy. It takes time and effort and courage, but it's possible. More possible than you think. The law is written in plain English. Court procedures are public information. You don't need a law degree to understand your rights. You need patience and determination and refusal to give up. If you're facing eviction, document everything first. Photograph conditions in your apartment. Save all communication with landlords. Check if you've recently filed complaints or reported violations. Research retaliatory eviction laws in your state. Look for patterns, look for inconsistencies, look for the same things Mason found. Then fight. Not because you'll definitely win, but because silence guarantees losing. If you're not facing eviction yourself, support legal aid organizations in your community. They're overwhelmed, underfunded, desperate for resources to help people like Elena. Your donation pays for attorneys who can take cases pro bono, who can help people navigate systems designed to intimidate them into submission, who can turn individual victories into systemic change. Every person who gets to keep their home makes the next fight easier. Remember that injustice relies on isolation, on making you think you're alone, that your situation is unique, that no one else has faced what you're facing. But pattern recognition exposes that lie. Mason found 7 tenants in 1 year. 7 people who thought they were isolated, who didn't know others had faced the same thing. Connecting those dots turned individual cases into evidence of systematic abuse. Your story might be part of a larger pattern. Sharing it might help someone else connect those same dots. The law protects you, but only if you're brave enough to use it. Only if you refuse to accept that protection is reserved for people who can afford attorneys. Mason walked into that courtroom with a duct-taped briefcase and the audacity to believe he belonged there. That audacity, backed by preparation and evidence, was enough. Not because the judge was kind, not because the system is fair, but because the law was actually on his side, and he knew it well enough to prove it. Justice delayed isn't always justice denied. Sometimes it's just justice waiting for someone brave enough to demand it, someone willing to spend 6 months in a library, someone willing to stand in a courtroom and refuse to be dismissed, someone willing to believe that competence matters more than credentials, that truth matters more than power, that 14-year-olds can cite precedent as effectively as 50-year-old attorneys if they do the work. You can be that someone. When you see injustice, document it. When you face abuse, research it. When you enter courtrooms, prepare for them. The tools exist, the laws exist, the precedents exist. What's often missing is the courage to use them, the refusal to stay silent, the determination to make the system work the way it was designed to work. Not perfectly, not easily, but work nonetheless. Mason returns to that library every week. Not to study law anymore, just to remember what's possible when you refuse to accept impossible. Elena still works night shifts at the hospital, still plants herbs in the window boxes every spring, still lives in an apartment that's now code-compliant and safe. Their story didn't end with victory. It continued with normal life, with homework and work shifts and basketball games and all the ordinary moments that matter most. But they know something now that they didn't before. They know that when systems fail, individuals can demand accountability, that when institutions ignore justice, people can insist on it, that the gavel falls where evidence points, regardless of who presents that evidence, and that sometimes the most powerful person in the courtroom is a 14-year-old with a duct-taped briefcase and the absolute certainty that the law means what it says. So document the injustice you see, research the rights you have, support the organizations that fight these battles daily. Remember that silence protects wrongdoers, not victims. And know that somewhere, right now, someone needs to hear that they don't have to accept abuse, don't have to surrender their home, don't have to stay quiet. That story could be yours to tell. That case could be yours to win. That change could be yours to create. All it takes is courage, preparation, and refusal to believe that justice belongs to someone else. The law is waiting for you to use it. The precedents are waiting to be cited. The courtrooms are waiting for your evidence. Walk in with documentation. Walk in with knowledge. Walk in with the confidence that you belong there as much as anyone. And walk out knowing that you fought, that you made them prove their case, that you demanded accountability. Win or lose, that fight matters. That courage ripples outward. That voice inspires the next person to speak up instead of suffering silently. Mason Jordan walked into a courtroom expecting to be dismissed. He walked out having changed the trajectory of multiple investigations. Your story doesn't need to be his story, but it can be your story. A story of refusing powerlessness, of using tools everyone can access, of standing up when institutions expect you to sit down, of proving that competence transcends age, race, and economic status, of showing that justice isn't reserved for those who can afford it. It belongs to those brave enough to demand it.